Hello and welcome everybody to a live stream question and answer session that I never would have expected to be part of even about 30 hours ago. But here we are. I'm Shwin. I'm your host. I am joined by Mike Kasdan. He is an IP partner at Wigan and Dana, and he is an adjunct professor at NYU Law. Mike, thank you so much for coming on with us. How are you doing today?
I'm doing pretty well, and it's a pleasure to be here. And I also could not have imagined joining you guys. I love the fan community. I love the Knicks, but my worlds collided a little bit when I saw this complaint. So it's fun to get on and talk about it a little bit.
Yeah, this should be definitely fun and also definitely not my area of expertise, which is why I recruited you to come on with us. Before we get before we get started, I do have to mention that this show is provided by BetOnline, which is your number one source for all your betting needs. Get the latest odds, lines, and match reports for baseball, boxing, golf, and more. BetOnline continues to be the fastest and easiest way to place your wagers, including live betting and your favorite casino and card games available to play right from your phone. Head to the website or use your mobile device to sign up today and get in on the action. Remember to use promo code BELIEVE, BLEAV, for your 50% welcome bonus on your first deposit. BetOnline, where the game starts. Also, we'll mention very briefly, we do have super chats available. If you feel inclined to throw a little bit of cash our way, feel free. It would help with, general upkeep of the website, which, as shitty as a product as I might produce, it does require a little bit of dough for our wonderful production staff who
Indeed.
do much more valuable work than I do. All right, here we go. Okay, so Mike, this is your show here. All right, so I guess obviously this was a headline none of us expected at all to be coming across any desk, a news desk, whatever. Do news desks exist anymore? Who knows? But what I guess were your just initial thoughts as you read through the lawsuit itself, and I guess do you feel at the base level of it, like, is this some like just superfluous lawsuit that the Knicks are just being petty, or do you think there's actually like a case here that is, if nothing else, something like worth pursuing?
Yeah, I mean, it's interesting. Anytime you read a complaint, you have to keep in mind that, one, it's allegations. So, we don't know what facts will play out. Now, the allegations are pretty detailed. So it seems like they have receipts, but we have, yet to see that, facts play out in all sorts of funny ways. And also that we're only getting one side of the story so far, and, the Raptors, they denied it in the press. They said they're doing an internal investigation, but, in the legal process, they'll have their chance to tell their side of the story. But the initial thought was, wow, this is surprising because, I do all sorts of intellectual property in my day job, from patents to trade secret lawsuits. And, trade secret lawsuits have really increased, nationwide, because of, I think, employee mobility and data mobility and the increased importance of data and things like big data in the NBA. And this kind of has all those elements. But also, I think you also have to always think when you have, people, personalities like the Dolans in control, what exactly is going on here? And is this just sort of a very bold move, right? Going after and naming an opposing head coach and division rival. But, you never, I can't, you never see this type of litigation in sports teams. Some of that is because league constitutions, usually this is handled by the league. And so it's rare, but, as I'm reading, there are certainly some wrinkles, I think, that make it interesting and, some potential, pitfalls for the Knicks. But as I'm reading it and thinking through the elements of what a trade secret is and what trade secret misappropriation is, it's a pretty well-pled complaint. So that's kind of my initial, thought.
Okay, so I just have to ask this as a very maybe silly question, but is it normal to just take a dump on somebody in a lawsuit? Because they were very, very. I mean, and I understand like the nature of these things are petty in a big way, but is that like a normal thing? Because they made it very clear. I mean, they called the head coach of the Raptors, Darko Rajakovic, I believe is his name. I mean, they called him a novice head coach,
Yeah.
and then I don't want to get into like, I'm not going to read the whole paragraph, but they more or less were like, he doesn't have the acumen or knowledge to do the kind of prep work and preparation and all the stuff that goes into being a head coach and getting his team prepared. I don't know if that is that like part of the art of filing a lawsuit, or is that just kind of an over the top pot shot?
Yeah, no, it really depends. And I think that, that was kind of the most, let's say, colorful, part of it, where they said, oh, and he's a novice head coach. He didn't have any of his own stuff, so he stole ours. And there are questions about that too. Like, I'm sure the Raptors have their own analytics, and I don't know how much of that is true. But yeah, it was a bit of a pot shot. But the answer to the question as to whether complaints usually do that is sometimes yes, sometimes no. The standards in the U.S. for filing complaints, it's called notice pleading. So a complaint can be really bare bones. You have to allege enough facts, that the wrong you complained about, took place, and go through the elements. But sometimes complaints are really bare bones, right? Like, in a patent case, like, I have a patent, they make this product, they infringe it, they owe me damages, and that's the other thing. The other way to do it is to tell a bit of a story. And I think it can be effective on a couple different levels to tell a bit of a story. And I think the other thing working here is I got the sense that they were pretty pissed about it. And some of the I think some of it, some of what's alleged, maybe you can explain as kind of employee taking a bunch of his own files, but some of it was pretty brazen. And if they're watching and collecting this information and seeing people from Knicks emails send stuff to their Gmail account and tracking all this stuff, as it seems they were, and watching a dozen people from another team log into their proprietary information, I think they were pissed, and so I think that was part of it.
Okay. And I wanted to get into this because this is a question that we had a lot of people bring up in our Discord, and I actually saw it written also in a Sportico article about this lawsuit. I'm just going to read off this paragraph. This kind of sums it up. Like other major leagues, the NBA's constitution, which governs the legal relationship between teams and leagues, instructs that NBA Commissioner Adam Silver has exclusive, full, complete, and final jurisdiction of any dispute involving two or more teams or officials. Silver also has the right to launch investigations on any matters that may adversely affect the league or its teams and to impose punishments. The NBA, like other leagues, prefers for teams to resolve their disputes through internal arbitration methods overseen by Silver and out of public view. I guess my question on this is, the Knicks apparently contacted the league office and the Raptors last week. They did not inform either party, I believe, at least from what has been out there, that they were planning. According to the Raptors, that they were planning on filing a lawsuit. So one, now that a lawsuit has been filed, does Adam Silver have any authority here to just like, hey, no, like this is not happening? Or is this a kind of political game where he can maybe use his power and influence behind the scenes to get the Knicks to drop the lawsuit and, arbitrate kind of independently? Or, I mean, what I guess are his powers here now that the Knicks have filed this lawsuit?
Yeah, so it's really interesting question, right? And I think it's a great point, because you think about other disputes between teams or things that have come up. I mean, the ones that come to mind for me are like the NFL Spygate between the Patriots and the Jets, that big scandal with the Cardinals and the Houston Astros from 2015, that we're actually stealing a bunch of scouting related information, a little bit similar actually.
There was one in the Premier League a couple years ago where Liverpool was basically, they hired somebody from Manchester City's backroom staff, and then they were like, I mean, it's very similar. They were like,
very similar,
taking information.
Yeah, so you think about those examples, and I'm a Yankees fan, so I always think about the Houston Astros and the trash cans, and those all proceeded with league investigations. Now, the Cardinals Astros, there was also a criminal. He pled guilty. The guy who did it,
Yeah.
Correa. He got jail time and a fine. But all of those were league investigations, league punishments. Whether it was draft compensation or fines, or banning folks. And the reason for that, and I haven't studied the constitutions of each and every one, but I think they're all pretty similar. But I did look at the NBA's today, and it is true. The NBA Constitution, which it's out there on the internet, Article 24 is the authority and duties of the commissioner, and 24D says the commissioner shall have exclusive, full, complete. That's pretty clear. And final jurisdiction of any dispute involving two or more members of the association. The Knicks and Raptors are both members of the association. So it's interesting because I can't think of a time other than tampering, where I think there have been a number of instances, where the commissioner, there's a dispute, with recruiting one free agent, the timing of that, where Silver's gotten involved. But I can't think of a dispute like this where Silver stepped in. Now it's interesting because if you think about like Spygate, this got me thinking. The Jets didn't go sue the Patriots for unfair competition in federal court; they went to the league. Could they have made out an unfair competition claim or some claim? Maybe. Same thing with the Astros and those other examples. So what's interesting here is that language about the commissioner's powers, it seems quite broad. It hasn't really been tested in a way. So one question is, well, how would that be interpreted? Is this meant to give him the authority to do what he wants, or is it like when you sign an agreement and you say, I agree that I'm going to arbitrate and not litigate, and then therefore if you try to litigate, it gets kicked into arbitration. I think it's an unanswered question, and I'm really curious, kind of behind the scenes.
I feel like Mike, did he freeze? Am I alone? Okay. Well, this is great. Hope everybody's having a great night. He'll be on it back. He'll be back in a moment. I'm sure of that. In the meantime, if you have any questions, feel free to throw them out here in the comments, and we will try to get to them as soon as we can. As we are going through, I'm going to let Mike know that he is frozen. But again,
Hi.
if you have, oh, here you are. Okay, you're back. You're back.
Sorry.
You're good.
Sorry.
No, go ahead. Finish whatever your thought
I'm
was.
not sure what happened there.
Yeah.
The one with modern technology. But what I was saying is, the other level is kind of political. Like, is Adam Silver, who has a relationship with these owners, which isn't, as we know from sports organizations and watching Roger Goodell, there's a little question of kind of who's serving who, and is he going to go take the step of shutting down their lawsuit? I don't know. So it's an open question, but I think it's a really good one. And if you look just at the language of the league constitution, it seems like it vests all the power in Silver to handle disputes, even like this, even if he hasn't yet handled one exactly like this.
So I guess my question then would be, if you are the Knicks, and obviously, as you mentioned, Adam Silver, according to the league constitution and all these things, it seems that he would have, and obviously we have examples of like commissioner ruling on internal disputes between teams. We even saw this with our very own Jalen Brunson last summer. Obviously, the Knicks got hit with a tampering charge, and we lost a second-round pick. Oh no!
So glad he's here.
Yes, it was very, very well worth it. So if the Knicks decided, okay, we can go to Silver, but we are going to file a lawsuit. My question would be, do you think that's indicative of either the Knicks feeling like issues like this are not treated with the appropriate they're not treated with the appropriate level of just kind of severity as they should be, and they feel that they need to go outside of the league to get the kind of, I don't want to say justice, but the whatever the justice that they feel deserves or should be meted out to the to the Raptors in this situation.
Yeah, so I'm not in the room where it happens, and so I don't know exactly what's going through their mind, but there's certainly a calculus, right? And so this is a pretty unprecedented step, and going around the league is, I think pretty serious. So I wouldn't be surprised if there was some feeling of, this is beyond a league issue, like an issue like tampering. This is actually a civil wrong, and we want our day in court, and we think we can do better there. And what does that mean? Whether that means damages or some other benefit, or just the pressure you apply, or hey, we're not satisfied that second round draft compensation isn't going to quite get it done in our eyes. There's got to be some calculus that caused them to make this move, and we can get into it. But I think it's interesting because I think the damages part of their case is interesting to think about, because I think it's kind of complicated for the Knicks on that front, even though they have a lot of facts, or seem to have a lot of allegations and evidence on the liability piece. But yeah, certainly to answer your question, there's some calculus that went into going the route of filing a civil complaint and marching forward and saying, hey, we've got all these tort wrongs.
Right.
It's interesting, and I also think about just I don't know that 20 years ago, or maybe more than that, but just the amount of data and analytics and the amount of valuable information that sits inside a basketball team, and that's portable in this day and age, is so different from the way it used to be. So it's kind of interesting to see this as kind of like a byproduct of the data analytics age. But it is pretty unprecedented.
Yeah, for sure. We got our first super chat of the night. Thank you to Larry Israel. He has a question for you, Mike. Is the main difference? Sorry, let me put it up here. Is the main difference here between Knicks and Raptors, as opposed to some others Mike mentioned, that crimes are alleged as opposed to violations of league rules?
Yeah. So the Defend Trade Secret Act can be criminal. It's used to prosecute, Chinese hackers and that sort of thing. We'll say these are civil wrongs, so that's not crimes, I don't think. I think and also, yes, there can be criminal activity in the computer hacking piece, as was the case in that Cardinals Astros, and that is one of the claims here. But this is a civil court; it's not a criminal complaint. It's not the Department of Justice. But that is one distinction that you can draw. Like this is, and that might be kind of informing the Knicks' thinking here, right? This isn't just a league rules issue. It's actually a civil wrong. Like we can make out the elements of unfair competition, trade secret, and conversion, and all this stuff. So that to me, it makes sense. That is a difference. Is it a difference that matters? I'm not so sure. Because if you look at the league, the language in the league constitution that I read before, it's broad, and it doesn't say that Adam Silver only has the exclusive power to deal with disputes involving league rules. It just says all disputes. Now they can make arguments about what that means and whether it's intended to encompass this, but so that is a difference. I'm not sure that difference necessarily gets them around the broad powers of the league office. Although, like I said, there may be other things at play. Whereas now that they filed this lawsuit, is the league going to shut it down? Do they want to get into a sort of combative place with one of their owners, or is the league going to say, okay, we're going to investigate this in parallel?
Yeah. Okay. Thank you for that question and contribution, Larry. That was very, very nice.
Yeah, thanks, Larry.
I guess so. I want to go. You've mentioned trade secrets a few times, and just there are three elements to prove. I guess this is just what I'm reading.
Yeah.
A trade secret is information that meets three requirements. Could you just briefly go over what those requirements are that the Knicks would need to meet, or I guess prove, to kind of for the Raptors to be found liable in this civil suit?
Yeah. So the elements of trade secret misappropriation are pretty basic. It's almost like exactly how it sounds. So first you have to prove that you have an actual trade secret, or number of trade secrets. And we've seen this in other industries, right? There were really famous trade secret cases between about self-driving cars and stealing technology. It doesn't always have to be technology. It can be any information. So you have to prove first that you have a trade secret.
Just
Yep.
walk over to Wall Street,
Yeah. So trade secret is really broadly defined. So trade secrets are any type of information, can be technical, can be financial, can be algorithmic, that is kept secret. So there are steps taken to maintain its confidentiality, and that have commercial value or confer a competitive advantage. So you have to prove that you have trade secrets. And that actually, in most lawsuits, if you look statistically at what happens to trade secret lawsuits when they're filed, a lot of them fall down right there, because a lot of times companies have confidential information, but they don't have a list of the crown jewels, right? Trade secrets are thought of as the iconic one is the recipe for Coke, or the Kentucky Fried Chicken recipe, or how to make my semiconductor wafer. So you have to have a list of these trade secrets and then rules about accessing them. Right, you're not allowed to disclose these. There maybe only certain limited people can access them in terms of sort of technological barriers. In this case, the Knicks in the complaint showed that by agreement, right, they have certain types of information that when you're an employee and you're doing video editing and analytics, you agree that this stuff is proprietary. You're not going to disclose it. That's an example. So you have to prove that you have a trade secret, that you protect it. So you take those steps, and then that someone took it without permission. Those are the elements.
So getting into the permission, I want to read this out. This was from the Athletic piece that was dropped yesterday by Mike Workinov, Fred Katz, and I believe Eric Corrine, who is the Raptors beat writer for the Athletic. This very, very brief. The lawsuit alleges Azatam, the Knicks' former director of video analytics and player development, stole proprietary information, including scouting reports, play frequency reports, a prep book, and a link to third-party licensed software, which I presume is the Synergy account of the Knicks. So, this guy obviously was in a position where, again, he is handling and doing a lot of stuff that helps the Knicks prepare and gather data, collate it, present it in such ways to help their preparation, right? It's not just collecting the raw data.
Right,
It's
exactly.
putting it in organized ways that you then distribute around the organization to your team, however, to help your preparation and hopefully your performance on the court. So my question is, if let's say he did steal this, right? Is it reasonable though that the Raptors could argue, or the Raptors lawyers will argue, that yes, he did take this data from the Knicks, but it is reasonable to assume he would have been able to recreate this anyway, because the guy has been doing this for you. This is his job. This is why we hired him. He's going to do it anyway. He just took his own stuff. And is that a reasonable counter argument that they could make?
Yeah, that's not. I mean, if this is Knicks proprietary stuff and he signed an agreement saying that this is Knicks information, I don't think that's a very strong argument to make. But I will say I think there are a couple things at play here. If I can sort of go from the big world to the sports world, one of those things is I think we see, especially in sports, but really in every industry, right? Like data, competitive intelligence is super valuable, and competing in a hyper competitive environment, people want to go right up to the line of doing that, and sometimes that line is crossed in some of the examples I mentioned. The other thing you see is employees. Like, this always comes up, and I think the Defend Trade Secret Act was passed in 2016 to finally have a federal trade secret cause of action. It's been very widely used because employees move around a lot, and we're at a place where you can take a thumb drive and take all sorts of valuable information and data. And I think sophisticated companies, as you'd expect these companies, these teams to be, they're really careful about this when you're onboarding and exiting employees, right? So you have an agreement, you do an exit interviews. They're like, you know what you can't take, you know what you have to leave behind. And I think the new company that hires someone, you don't want to buy yourself a problem. Like, it's one thing if the Knicks have a cause of action for breach of contract against this guy, but if you're an opposing team or another company, if you hire someone, unless you're doing some nefarious stuff, you're really careful, and you're saying, look, we don't want you to bring stuff from your old firm. We don't want you to take zip drives and install them here, because that's just asking, for trouble. Now I think, I did this like piece with the Wall Street Journal. I'm sorry, with the Washington Post like last year, just about employees moving around and the reality of, like, you have your laptop and you got stuff that's like your personal stuff, and and it's mixed up. And what are you really supposed to do when you move, and what are you supposed to give back, and how do you deal with that situation where you have like mixed data? And I think, the sort of most favorable, based on only on these allegations, right? I don't know the other side, and I don't know if these allegations are factually true. But if I assume they're true, I think at a certain point of reading, you can say, okay, well, this guy probably created that stuff, like you said, and equitably, you're thinking like, he's thinking like, okay, this is my stuff, and I could maybe recreate it. But the reality is, he's had a contract that said otherwise, and this is kind of company information. So so you can think like, look, this maybe this happens a lot, and maybe it happens that because it happens a lot, we have all these trade secret actions because people are taking data from companies that they shouldn't, and moving around. But at a certain point, if you continue, when you continue reading, and you see the involvement of, these 10 unnamed folks on the Raptors and the head coach and people accessing stuff and sending the password and them accessing it thousands of times, it's hard to kind of read it like favorably and innocently, where he's just saying, hey, have a couple files that I worked on and I consider that my stuff.
I am not a lawyer, which I don't think anybody would be surprised by. But in this, throughout the lawsuit, on several occasions, it mentions, he provided X material to the Raptors defendants, and Rajakovic, sorry, he is named specifically as a defendant. I believe one other coach, Lewis. He is
Lewis.
Yeah, he's an assistant video coordinator and player development coach with them. And then there's 10 John Does in the lawsuit that are also named. So bring it back to Rajakovic, if he is named as a defendant and they're saying that Azatom was providing him information, is that more or less indicating, or at least the Knicks are alleging, that this was a direct communication between the two? The way they make it sound, at least in these are allegations, are that to some degree, Rajakovic was using the information that was was from the Knicks to aid his own coaching preparation. If he's directly communicating with him, does that put him in serious hot water in this situation? And do you think, if the Knicks actually have the evidence to prove this stuff, could that be something where it costs him his job before he even has a chance to coach the team?
Yeah, I mean, I'm not, don't want to speculate too much, but, another thought that I think I had when I first saw the lawsuit was, well, maybe this guy took a bunch of stuff and, there wasn't really higher level, knowledge on the Raptors side, right? And that doesn't necessarily cure it or save them. But when you see the incoming head coach named in a lawsuit, and we don't really know whether there was direct communications, and they named these John Does, I think because they don't know their names, but it sounds like they have a lot of electronic and surveillance type evidence, and they probably have 10 IP addresses that they can trace back to the Raptors, because to allege in a complaint, you're supposed to at least have some sort of base, like a non-frivolous basis. You can't just say like, hey, I think it's true, and I think this is true, and there's no basis or evidence. So the facts have to bear out, but in order to make the allegation, under Rule 11, you're supposed to have some reasonable basis. So just the fact that he's named, I think, is a pretty big deal and is pretty eye-opening. We have to see what his involvement was and whether the evidence really does connect the dots, or if it's assumptions and sort of suppositions. How strong that evidence is, we don't know, but they had some basis to name him, and it's pretty eye-opening and bold.
So we have a few questions that are streaming in here from the comments. This first one is from Fountain of Hoop. Shwin, how do you feel about Woj, Shams, and other major media heads not saying anything about the situation? I'm going to actually throw this to you because I know that at least, and I know the rules in different countries on reporting on stuff like this is different. At least, in England, English Premier League, I follow the English Premier League. When there are situations that go to court, they often won't name who the defendant is. Like those things are very, they basically put a tight lip on that stuff. You're not allowed to talk about it at all. I don't know anything about intellectual property. I don't know anything about civil litigation at any serious level. So my question to you is this a situation where some of these guys, like let's just say Woj and Sham specifically, they are not comfortable, or they're not able, or they're not able to really talk about it in the detail they might want to, because of the nature of the lawsuit? Or do you just think, I mean, I don't want to say it's a conspiracy against the Knicks, but do you just think it's like they don't even know what to really report on here yet?
I mean, this is a public filing. So they can talk about it just like we can talk about it. We can read the complaint, and if it's newsworthy and they want to talk about it, they could. So I don't know that it has anything to do with the Knicks. I guess if I were to guess, and be a little cynical, then maybe in the same way that ESPN doesn't necessarily like to report on things that make the NFL execs or leadership unhappy, then maybe they're just shying away because, and I don't know what's going on, behind closed doors, but the league's not happy about it. If there's a league investigation, of course, the fact of that investigation is public, but otherwise there's, it's kept under wraps until there's a decision announced. So the public nature of having a filing in court, if in fact the league is not happy about it and they've communicated that, then maybe that's just a reason to shy away from reporting it.
And thank you for that. I'll go ahead and say, like, I don't love it, and I'll just finish and say, to answer the question very succinctly, I think if the roles were reversed, there would definitely be reporting on it. And I don't think there would be a large refrain of people saying, oh, well, it's not a big deal because the Knicks, all they did was take synergy clips from Toronto. How's that a big deal? I don't think that would be any serious person's argument, and I think they would be getting, maybe rightfully, criticized for even being alleged to have committed these crimes or this illegal action, however you want to put it. This one is from JK. How much merit is there to the claim that every team has access to these same synergy files? I feel like people are considering all synergy data as relatively the same. Is this not the case? We actually just got a synergy account for Strickland. I have not fucked around with it. Prez has. That's Prez's thing. I just pretend like I'm smart. But from my understanding, like, the way I think about it is this: forgetting, how much can you really tell? If you have access to a team's entire synergy account, you can see what clips they're pulling up. You can see how they're organizing them. You can probably distinguish and kind of figure out, well, maybe they value XYZ thing. Maybe they're seeing this thing. Maybe they like this thing. Maybe they don't like this guy, that guy, whatever. You can find out a lot about how they're evaluating things, their personal preferences as an organization, on players, teams, whatever. And I feel fairly comfortable saying on synergy, I believe that you can write comments in and mark stuff up. And if that's the case, you can find out a lot. Even something as simple. I mean, I remember this happened earlier this year with like Joe Mazzulla, where I forgot what account it was on whatever the hell, platform it was on, but somebody found out his account and started leaking some of the stuff that he had out there. And one of them was really funny. It was like, he had notes on like Emmanuel Quickly, and it was like, he is a point guard. And people were like, see, he's a point guard. We told you all along. But like, so you can, I think, I don't know enough to say, one, the Raptors totally did this, and now they have so much information on the Knicks, and the Knicks are, how can we like recover? Like, I'm not saying that, but I think to argue that you cannot learn anything from this, and it's just like going to the NBA.com site, and we all do this, right? Take the video and clip it up ourselves and whatever. I don't think it's that. I don't, and even with that, look, you guys could probably figure out players I like, players I don't like from the things I clip. It's not too hard to figure stuff out like that. So I think it's ridiculous to argue otherwise. Mike, I don't know if you have any thoughts on this.
Yeah, a couple of thoughts. One, and I'm not as familiar with synergy in particular as probably folks out there or you are. But first of all, there are some people saying, predictably, sort of dogging the Knicks and saying, oh, why would you want to steal information from, the Knicks business plan? It's a shitty business plan because they're the Knicks. First of all, I think we're well past that. But also, this is not, when you look into the type of information that's alleged to be taken, it's not all Knicks information. It's not all and it's not all Knicks information about the Raptors. They also had, information about the Pacers and the Mavericks and the Nuggets and analysis of player tendencies and statistical stuff. And so that's just valuable information. It might be the Knicks' take on it. But I think that's, certainly useful, right? If you say, okay, well, take all this film on, that someone smart crunched and see if it's useful. And then you get into sort of the game planning stuff. And I think the thing, at least, that jumped out to me about the synergy stuff is that it is customizable. And you can suss out, team approaches, from that. I think there's also allegations that they took kind of the Knicks like prep book and game plan
from two games. Yeah. One was the last game of the year against the Pacers, and another was, I believe this was the second time they played the Nuggets. I want to say maybe in March at the Garden. So like whatever you can. I mean, it's kind of funny to think about. It was like 250 pages worth of stuff, and I'm like, do you really need 250 pages of just like, yeah, Jokic, really good. Like he can pass. He can also score really well. I don't know.
But that's another thing that I did think. I mean, to be fair, as I'm reading this, you're thinking, why would they do this or necessarily really want this stuff? And it's really hard for me to say as a layperson, or for us to say without really understanding what they had access to, how valuable it is and why they might want it. But, these days it seems like every team has their own custom library of all their information that has all the opposition players, competitive intelligence and tendencies. So it is a little curious when you step back and think about it, and you're like, and yes, there's the allegation he's a rookie head coach and he's dumb and doesn't have his own stuff, so he had to steal ours. But I mean, in reality, I think the reality is everyone's built to some level, towers of this analytics information. So it is a little strange, right?
Yeah. And if you landed a head coaching job, I have a hard time believing that you didn't have any idea of how to do this stuff. I'm going to read out this comment, and I think it's fair. Please pronounce the coach's last name correctly, or just call him Darko. I looked it up. It's Rajakovic. Sorry. Thank you for listening to a Knicks podcast, by the way, because you're clearly not a Knicks fan. Rajakovic. I will be correct with that from now on. I think this is worth mentioning. Several people have brought this up in our Discord. I think the first one may have been Larry Israel, who, again, thank you for the comment earlier. But he mentioned, and I think this, again, is worth bearing out. Like, one of the few things, whatever, we've all been critical, especially me on this podcast, of Tom Thibodeau's various coaching decisions, whatever. One thing he is universally recognized for, that he is universally praised for by his peers, by media members, consistently, this from his time as an assistant through all of his time as head coach, His teams are very, very well prepared. They are very well prepared for each game, for each opponent, everything. He is considered by many the best in the business in this one very specific thing. That is it. I am not calling Tom Thibodeau the best head coach in the NBA. I am saying that he's often regarded as the best in pregame preparation in the regular season, whatever. Okay. It is not crazy to me for a rookie head coach or an organization employing a rookie head coach, having hired a rookie head coach in the NBA, to feel like, hey, if we can get access to this team in our division who is actually really that is their big thing, that's the thing they're the best at, this could be useful for us to prepare ourselves, and it gives us an insight into them as an organization, as a rival organization. I personally think like that's not outlandish to really look. It's a competitive league. You're kidding yourself. I think anybody that thinks this is the first time in the history of the NBA that a team has maybe tried to take data from another organization is kidding themselves. That's ridiculous. But I just think that there is something to that, and I do the Knicks go overboard in the lawsuit and take some pot shots at him? Of course they did. But to your point, like that language may have been in there for a reason, and they were very, very specific about calling him a novice and saying that basically like you are taking all the preparatory materials and how we do that, and you're trying to use that to benefit yourself and make your transition easier. I mean, is that a correct way potentially to read that? Or, is that just kind of like, yeah, maybe, but you're connecting stuff that we can't really prove?
No, I mean, I think that's a reasonable take. I do. And I also, to be fair, laughed when I saw someone tweet out like a piece of paper with the Knicks game plan on it, and it said ISO Julius 3 times. So there's that. But no, I think it's very reasonable to look at it that way.
Yeah, just give the ball to Brunson, run a pick and roll, maybe. This is we got a comment or a question here. This is from Omar Yusuf, who is in our Discord as well. If the Raptors are found in the wrong here, would they be open to investigation from other teams who might have had employees moved to them in the past?
Yeah, interesting question. So one thing that happens when you sue someone in federal court or have these detailed investigations where there's discovery. And I think we saw this happen in the NFL, where there's this big investigation and all sorts of documents about one thing bled over into other things. So I think if the lawsuit proceeds and there's discovery, it could open that up. I don't know, the history and whether there's any there and whether they've hired people from any organizations, whether that stuff would come out or not. But it's a possibility for sure. I thought part of that question was going to be, if they're found to be wrong, what would happen to them in terms of damages, from the lawsuit.
I was wondering this. Do you think a reason the Knicks may have went this way is, one, they want the league off? Like, let's put our cards on the table here. The Knicks absolutely tampered with Jalen Brunson. Tampering happens with players all the time. We have seen the league investigate these matters, and what is the sum total of that? Usually we'll dock you a second round pick, right? It's not very significant. Do you think
we got lots of second round picks?
Yeah, we do. Good job, Brock Holler. But like, do you think part of the reason they may have gone legal with it is, hey, we want you to take this seriously. We want you to take this more seriously than you take these tampering charges, which to me, like, by the way, I think the tampering rules are stupid. But like, they are the rules, and this is how you've chosen to enforce them. We think this is a lot more serious than tampering, and we want you to, if you want us to come back to kind of like, take it off the legal side, and we come back to the league and we're like, hey, you guys make the call here. We want more than just docking them a second round pick. And in that case, does the league have the authority? You mentioned the Astros earlier. I believe they ended up having to, I think the Cardinals gave them 2 picks.
Yeah, they lost 2 picks, and there was a fine, and a couple of people suspended. I think.
Yeah. So do you think the Knicks are like, we want our pound of flesh, right? Like, we want more than just a second round pick doc. We want a pick. We want you to fire, get their head coach out of here. Is this? Do you think that's part of the reason they could have done this?
Oh, I absolutely do. I mean, I think first of all, you have to think about the personalities involved, the types of people. Dolan's is a sort of transactional bully kind of style. I think
He's very petty.
Yeah, but also like I'm going to try and leverage and push people around, and I think you have to look at this, on a legal level, sure, but also look at it as a leverage play, right? So on a legal level, like sure, you have the commissioner that has exclusive powers, and everyone else has always, gone to the league and said, hey, will you please investigate this? And the Knicks said, we're going to file in court, and almost, we'll see what the league does. But is the league going to shut that down? I don't know. So I do think that on a certain level, it is a leverage play to sort of put pressure, to say like, hey, this is a serious thing. We're upset about it, and some calculus that filing in court is going to get them more. In the sum total from the league and whatever happens with this lawsuit, than just going to the league and going through the normal process.
Yeah. Okay. Thank you for that.
Yeah.
I'm gonna dive into some of the questions that we had populated in our Discord today. This first one is from Duder Adam. What is a good analogous crime to this alleged crime? Ideally, a non-sports related analog to give perspective that isn't colored by fandom bullshit.
Fandom bullshit. I thought that's the whole point of all.
It's a big part of what we do.
But I mean, the analogy is kind of the more, I don't want to say boring, but the more in non-sports industry, I see this all the time, and you can see it all the time in the news. Some you can read about, hacking. You read about an employee leaving and taking with them a bunch of blueprints. Now there are some differences. I think in the ordinary trade secret case that gets a big damages award and makes it into the press. It's like, hey, I'm working on this technology, and they hired away my designer, and then lo and behold, 3 months later they came out with a product with all the same features that we were working on. And you investigate, and they took a thumb drive full of all their stuff. That's the analogy. Is it of the same magnitude? And it's hard to say, because there are some wrinkles here, because and that's, I think, where the damages issue comes up. If this proceeds and the Knicks win, I think damages is kind of a tricky thing here, because ordinarily damages under the Defend Trade Secrets Act is really broad. You can get the profits that the other side makes from stealing your trade secrets. If you can't prove that, you can get some reasonable royalty. You can get like disgorgement of profits. You can say, hey, here are the profits I didn't make. You can get treble damages for being really malicious. So there's a big hammer there, like in the statute. But ordinarily, what you're talking about is like marketplace competition, where you can prove that because they took this, they built this competing product, and I lost sales because of that. And here we have that weirdness of it being in sports, like the game inside the game inside the game, where we're talking about the on-court. Like, are the Knicks losing money because of this? I don't know, but they might lose to the Raptors, one more game. And what does that mean? And how do you compensate that in terms of damages in the trade secret case? Those are really complicated questions. But I think the analogy is just an employee leaving one job, taking a bunch of stuff, and giving it to their new employer. And that happens all the time.
Right. Proving counterfactuals is it's a difficult world to live in. Next question from our Discord. This is kind of a funny question. This one is from Zach, our art guy. On a scale of 1 to 10, how fucked are the Raptors?
Yeah. So let's see. Not legal advice, and I'm not going to be pinned to this, but it's so early. It's like hard to say, but and they always look more fucked than they do when you just read the complaint. I still fall into this trap as a lawyer. Like, you get one side's motion and you're like, ooh, that's good.
Right.
And then 2 weeks later, you get the other side of the story and you're like, it's less good than it looked. And, the dots really connecting here. But I think, look, if you're looking at the allegations and it seems like from just the way they wrote the complaint, there on the liability side, there seems to be a lot of evidence that stuff was taken and that shouldn't have been taken.
Yeah.
So I think on the liability side, it seems like at this point, reading tea leaves, projecting caveat, like fairly fucked. On the damages side, though, I think it's hard to say like what's the real damage, and that's, I think, an uphill battle for the Knicks on trade secret claims.
Yep, for sure. This one is from Here Comes the Jab Stepper, aka Squeege,
I like it.
in our Discord. If it is true that similar behavior is relatively widespread in the league, would that have any effect on how a court of law judges the outcome or severity of the case? And then he had a follow-up question was, if it's proven that members of the Raptors staff, aside from Azatom, accessed the data, what would need to be proven true for the Raptors org itself to be held liable?
Yeah, good questions. So the first question is, if behavior like this is widespread, would that make this behavior more excusable, or potentially, reduce the damages or help them on liability? And ordinarily, in a litigation, you're really looking at the wrong. You're really probably not going to get evidence in of other people allegedly committing or not committing acts. That evidence is probably going to be considered, kind of speculative, and it's like, we're not going to try 10 cases inside this case, and you're probably not going to be able to get that in. So usually what the court looks at is the conduct at issue. So I don't think that really helps them all that much. Now I think there may be a way to get that sort of evidence in on damages, and maybe that can sort of mitigate, where if you show everyone's got this kind of information and it's really not all that valuable, maybe there's a little bit of upside there, but generally that's not really going to be that helpful. And then what was the second question? The second question was, what would you have to show to really make this stick against the Raptors? And I think that's another really good question, because, it's one thing for Azatam to be this rogue employee and to have a lawsuit against this dude and say, hey, you breached your contract and you took the stuff that you shouldn't have. And he's probably not all that deep pocketed in terms of, collecting some award versus him. But if you can make it stick against, the Raptors at the management level, that's a whole different story. And I think that just comes down to the actual facts here, which we don't yet know, but alleged, that there are 10 members of the Raptors, and they had something that made them name the head coach and this other coach, where it seemed, and they alleged that he was being directed and being used as a mole. And so it seems like, if those facts are true, and it wasn't a situation where he just showed up at work one day and had this information that, oh, we had no idea, we didn't ask him to do this, we don't want this stuff. That's a very different situation than the one that's pled. So if the facts line up, then that's why the Raptors and the Maple Leaf organization is named, and that's what will be required to make it stick against them.
Awesome. He has a third question. It's actually a very good question also. If the league itself handed down a punishment to the Raptors, would this have any effect on the severity of any subsequent punishment given by a court to the Raptors? For example, let's say they lose a second-round pick. Could the court view that they've already received some punishment and lessen the fine they'd have otherwise gotten?
Yeah, I mean, it's a good question, and I don't know the answer 100%, because I can't think of another case that's quite in that same factual scenario. But so I think in terms of the damages case, I can't think of a case where you reach a damages part of a trial and you're looking at, lost profits or reasonable royalty or the types of damages measures that are in the statute, and they say, oh, but wait, they also lost a second round pick, so we should make it a little bit less. So I think it's possible to say that you've already been compensated from this other place, and that should be taken into account. But I'm not sure that I've seen that. So the answer is I don't know.
All right. Yeah. Thank you for that. And then we have a question here from Larry Israel again. Could the Knicks system of organizing information, the methodology, the responsibilities of different people, and the actual assembly line as a whole be considered proprietary?
Yeah, it's a good question, and uh, it could be. I think we'd have to dive into, what you mean by the system of organizing information, but certainly, I've seen. You can think of. I haven't seen it in the sports context, right? But then again, this is a pretty unique case, and maybe the first of its kind in the sports context. Now, the responsibilities of different people, like, hey, we have this special trade secret way of doing video analytics where we have these three people look at this and put this information in this place. Theoretically, it's possible. I think practically, I'm not sure that they'd be able to show that that's something that gives them and connect that to kind of an economic or commercial advantage. But it's possible. Trade secrets can be pretty broad, and I think about, the way we make this widget, our special process for doing this, the suppliers we use, the way we organize our supply chain. So you could get into the nitty gritty there, but it doesn't seem like that's what they're going with here. They're basically saying, more traditionally, we have this information that we've gathered, these sort of custom, reporting that shows how we track different players and analytics about that and game planning. And that's what they seem to be relying on as trade secrets.
Yeah. I wanted to get back into the Sportico article, which I'll tweet this out when this pod comes out in the morning. But I thought this part was interesting in terms of, we've been obviously talking about it from the Knicks angle. The Knicks obviously have only been, they're the only people that have really provided any allegations. The Raptors haven't had a chance to respond or anything yet. But I wanted to bring this up again. So I'm just going to read this out. In answer to the complaint, the Raptors could argue the Knicks failed to exhaust the league's dispute resolution system before suing.
Definitely.
The team might also question why the Knicks didn't turn off Azatom's work email account if they suspected he was dispatching property information. And just so we're clear, Azatom told the Knicks on July 25th that he had received an offer, a great offer, or whatever the exact verbiage was, from the Raptors. It's not specified that he told them he was taking the offer that day or that he put in his 2 weeks notice that day. Either way, his contract was ended on August 14th. I believe on August 15th, they had proof of Azatom and others taking information from the Synergy login or whatever it was exactly.
Yep.
So to go back to kind of like what those arguments are that the Raptors could make, is that kind of like where their argument do you think that's what they will be arguing? And what exactly are the merits of that argument and what would they need to prove?
Yeah. So on the first point, and that was a good article. The first point is, could the Raptors' response be, hey, you don't have standing to sue us in federal court because under the league constitution, this dispute has to be dealt with in this other place. And
you didn't try.
And you didn't try.
Yeah.
But I think it'll be interesting to see if they make that argument, because the parallel that you see in cases all the time is lots of agreements we sign, we agree to arbitrate instead of litigate. Sometimes we don't even know it. But you have a work order or a supply order, you order a thing, and on the back it says, hey, if there's any dispute, you have to arbitrate. You get into some sort of dispute. If I file litigation, a lot of times the answer to that is no. Actually, you're supposed to arbitrate it. Litigation should be thrown out. So if you go back to that Article 24 of the league constitution, I think it's an open question as to whether a third party can use that to say, hey, the exclusive authority lies in Silver, or if the interpretation of that is, hey, this gives Silver the authority to do it if he wants to. And it's for him to decide, not for you to use as a shield. I think that's an open question, but I can certainly see. But I think if I'm putting my defense cap on and I'm on the Raptors side, I think that's a viable argument to make in response and say, look, this isn't the forum. We agreed to a different forum. We're both, member teams. We have this constitution that governs, and this shouldn't be in court. So that would be an interesting one. I think the second point about, hey, if they knew he was doing bad stuff, isn't it on them to turn off his email? That kind of rings more hollow with me. He was still employed there. He was doing bad stuff. If they wanted to watch him do bad stuff and watch where it went and see if there was a broader thing happening, then fine. And I don't think they're under any obligation to say, terminate him once they suspect something. If they see him doing some bad stuff and they want to watch him for a little bit, I think that's totally, not only up to them, but probably a smart thing to do.
That's what the RICO investigations are, right? They take years, even though they already know. That shout out to The Sopranos. I actually have a question based on your answer, though. Like, could the Raptors then argue, hey, if this stuff is so proprietary and it could be so damaging to you, then you would have immediately cut off his access once you saw he was doing something wrong. The fact that you let it go on for longer, sure, maybe there are damages you incurred and you might incur, but they cannot be that serious if you were willing to let it happen for so long. Is that an argument they could make, and would that have any standing legally?
Yeah, I'm trying to think about what point it goes to. A lot of times when you're seeking not only damages, but an injunction, which they're actually seeking here as part of the remedy. They're saying an injunction, they want to enjoin the Raptors from continuing to use this stuff and to spread it. One of the things you look to see is the urgency with which folks act. And that informs whether they really need an injunction, whether there's really immediate prejudice and harm. And that point kind of lines up with that. It also maybe lines up with, is it some evidence of how much you consider that thing to really be a trade secret, and maybe, some might expose that a little bit. So I think that could, that argument could be made. And I think it's a factual question and a kind of a jury kind of question. And I think the flip side, would be like, hey, we were watching him and we thought there was a bigger thing going on and we wanted to track it and find out. But I think you could make some hay with that a little bit. How much? I'm not sure how much.
Probably depends on the lawyer, right? How good you are. This is a question. This is actually tied into kind of what you just answered here, so I'm going to throw it in. This is from Larry again. Wasn't one of the things the Knicks asked for injunctive relief? Can you answer that? But before you answer it, can you maybe explain to anybody that's listening that doesn't know exactly what that is? What is injunctive relief, generally speaking, and specifically in this case?
Yeah, so remedies to lawsuits can come in a couple different flavors. The one that we're all really familiar with, that happens all the time, is money as a remedy, like damages. Right? So if you breach a contract and there's no amount of compensation. Another thing that you can get, and oftentimes can get in competitive situations and intellectual property lawsuits, is for the court to issue an order that you can't do certain acts. So an injunction, or preventing you from doing certain things. So to enjoin you from doing something. So if you look at the very end of the lawsuit, which in very general terms, doesn't have to be specific at the beginning, says, what's the relief you're looking for? And they basically say, we're looking for an injunction for them to stop using the stuff and stop further disseminating the trade secrets, because there's harm to us. We want to lock it down as much as possible. And we're also looking for damages. So in this case, they're looking for both.
Okay. I wanted to go back. We talked very briefly about the fact, they had this thing. It's one email. I'm just going to read this again from the Sportico article. Would highly recommend everybody read that. With the emails were supposedly in response to Raptors' requests, with one email titled Forward Indiana Game 82, and that included an advanced scouting report on Indiana Pacers players and comprehensive diagrams of over 250 Pacers plays. He allegedly sent a similar email involving intel on the Denver Nuggets. Could obviously this is the Knicks alleging, some wrongdoing on the part of the Raptors here. and how it materially affects them. Could the Pacers and Nuggets also like? I mean, they seem to have been brought into this in some capacity. Is there any argument for them to like be like, hey, like what the hell? We're gonna sue the Raptors too, or is that just like they would need way more evidence than just one email can't get it done?
Yeah, I don't think so. It seems. I mean, from my reading, these were the sort of the Knicks video and analytics takes on, from the game film or from other inputs against those, for those teams. So I don't think that those teams kind of own that information or keep it as trade secrets. And I think the trade secret part of it is kind of how the Knicks collected it and analyzed it and put it together. So I think it's like, I think the Mavericks and the Nuggets and the Pacers, all of who were mentioned here, kind of do a little like, oh, okay. But I don't think there's anything actionable that I see from this.
Okay. So sorry, 1 second. This is from Vivek in the chat. I'm gonna bring it up here. Is it a coincidence the Knicks aren't asking an exorbitant amount in damages? It's been a trend in some of the biggest DTSA cases in recent years, but I believe New York has been stingy in awarding damages.
So I think we're just not at that point yet. Ordinarily in federal court complaints and complaints of this type, where there's a number of violations of different torts, the damages is left kind of unstated. They just say the sort of the type of damages, the type of remedy, and they sort of have to go through discovery and experts. And so I think I wouldn't say that they're not asking for an exorbitant amount of damages. I think we just don't know yet. It is true that there's some big DTSA, Defend Trade Secrets Act, that's the Federal Trade Secret Act's damages award. As to New York being stingy in awarding damages, I'm not sure if that intel is under like the New York trade secret, law, or just in general. But I think basically on damages, it's just too early. Unless you have a complaint where you're like, the contract said you were going to pay me $300 and then you didn't, and your damages claim is therefore for $300 or whatever else. Usually at this pleading stage, at the early stage, you leave damages kind of open. So they could ask, for some exorbitant amount. We just don't know it yet. Although I do think that the damages case has issues. I think it'd be difficult for them to, they have some challenges there on the damages case. But we just don't know what it looks like yet.
Yeah, got you. I wanted to ask you about kind of just your personal takes on this. When you were reading through, again, and I want to be very clear, I know that's mostly Knicks fans in here anyway, but like these are just allegations at this point. Nothing's been proven. But when you were reading through it, is there anything that when you were like just very specifically, were there a few things or one specific thing that stood out as like, man, if that's true, like I don't see how the Knicks can't, like how the Raptors could argue against that. Like, is there anything specifically or a few things that stood out in that sense?
I mean, I think that the few things that stood out to me were, one, just like I said earlier, in a lot of these trade secret cases, a lot of times what happens is companies have a bunch of confidential information, but they don't really treat anything as a trade secret. They might share it with people and they don't really control access. And then someone takes a bunch of stuff and they say, oh shit, and they file a trade secret claim. And then in the case, you have to say, okay, well, did you have a list of trade secrets? Did you identify it that way? Did you keep it that way? And that becomes hard to prove. Here, one thing that stood out is that, in the employment agreement, they identify all these categories of information. They have an interesting site to like a law review article that talks about big data and analytics in sports and how all of the general managers and folks kind of agree that this is highly confidential, proprietary team information. So it's interesting that the issue that ordinarily ties up folks on trade secret cases, and it's kind of ironic because it seems so fundamental, like showing that you actually have a trade secret and you kept it that way before the wrongdoing occurred. It seems like they have that kind of locked down. The other thing that I think just stood out was, pleading the involvement of not only a bunch of unknown people who could be kind of lower level and acting on their own, but just having enough, and I don't know what that enough is, to plead the involvement of the coach. Sort of seems like, if in fact those allegations that there were people of that level directing, and I forget the exact language the complaint used, but directing him to go back and collect this stuff and give it to them so they could use. That's pretty. That's a big one there, and that stood out as well.
Yeah. I wanted to ask you about this. We got one. This isn't even really a question, but I want to get your thoughts on this. This is also from our Discord. This is from David Quickly. One other thing about Synergy Gate. I like this. Maybe we should call this Synergy Gate.
Someone's really pushing Raptor Gate out there.
The Knicks were potentially going to trade with the Raptors this summer, and obviously, I'm sure anybody here, but just in case, the Knicks obviously have been connected with, have shown interest in OG Anunoby for a while, specifically. So again, the Knicks were potentially going to trade with the Raptors this summer. One thing that may have been leaked and what the Raptors were interested in was assorted OG, Siakam, whomever scouting focuses, to see exactly how bad they did or didn't want those guys. And I wanted to follow this up by asking you something where, I mean, this is such a weird thing to do, probably in a court of law, but like, could the Knicks materially argue that if they gained knowledge of their own internal evaluations of, let's just say OG Anunoby, because we know that's a player the Knicks have been interested in, that they could use that to their advantage in their own negotiations on the trade market, and that they could also use that in ways to hamper the Knicks' attempts to improve their roster via trade, whatever, in the offseason. Is that stuff that you can argue? Because obviously we know that, like, I mean, we've seen this in the NBA, right? Where teams, if they have intel, like, oh, we know this team loves this guy in the draft, so if we want him, we got to jump him. I mean, the Knicks a few years ago, when they drafted Quentin Grimes, it was reported after the fact that Grimes had a promise from the Denver Nuggets at 26. The Knicks traded back like 3 separate times to 25 and then took Quentin Grimes, our lucky pick, 25. And I just want to say I'm very happy Grimes is not on the Nuggets because, wow, he would be a great fit there.
So no matter where we start, if you talk Knicks Raptors, it always comes down and always comes to OG Anunoby. That's the moral of the story there. But I think, look, like, I think the last part of what you said, I think is kind of far afield, that they're kind of hampering the Knicks' ability to improve their roster. Now, theoretically, yes, there could be a cause of action where you got proprietary information about the Knicks' evaluation of that player and you used it to your advantage, and there was harm and that was secret. That could be a trade secret case. It doesn't seem to me, from the way this is pled, that is this one. But theoretically, you could have a case like that, but that's just not this one.
This is another example in the comments. Knicks drafted Jang because OKC wanted him and got 3 picks. That's true. That is accurate.
It is.
Yeah,
that draft.
I guess, like, in looking at what the Knicks filed, if you were the Raptors, let's put yourself as your general counsel for the Toronto Raptors, where would you start? Like, okay, this is where we're going to start poking holes at this thing. What are the things that stood out to you as, like, this seems kind of weak, or I don't think they have the juice to prove this part of it? Like, what were the pieces of that maybe stood out to you?
I mean, the one thing that leaps out immediately as a legal tactic is to try and get this kicked from court and back in front of the league. Otherwise, and the other piece is the damages piece to this. I think, and no one really likes to start there, right? Liability is where most people look at and they say, hey, like, we didn't do it. But damages is an important sort of component. If you're going to spend the money to litigate in federal court and go through a really expensive litigation, if there's no pot of gold at the end, it's a really good place to attack. I think also, the Raptors, from at least their statement, They said, hey, we're going to take a look at this internally and see what we come up with. But also we deny everything. So, on the liability side, I don't know that anything really jumped out other than kind of the weirdness of these trade secrets being things that helped the Knicks on the court rather than at the ticket office or in the business part, even though I understand, of course, those things are connected. So those would be kind of some of the things I would focus on if I were the Raptors. But I would try and get this, back in front of the commissioner and back to a place where I might lose a second round draft pick and some cash and do it in secret. Oh, I think I lost your audio there. Do you still hear me? It's maybe a sign from God that it's time to wrap it up for me. Yeah, I can't hear you, man. Sorry. Yeah, let me leave and come back, see if it fixes that problem. You talk amongst yourselves. I still can't.
How about now?
Ah,
All right.
there we go.
Great. Good luck to our fearless leader tomorrow of producing this pod.
We'll piece it back again.
Okay, so if I were to, I mean, we'll wrap this up pretty shortly here. We did get the sign from God just there. If you're the Knicks, what do you think is your ultimate end goal here? Is it to get damages awarded to you? Is it to have people removed from power in Toronto? And then very specifically, as far as Toronto is concerned, like there are 10 John Does listed in the complaint. Do you think that, like you mentioned that maybe they don't have the names, but they have the IP addresses?
It's a guess, yeah.
Is it possible that those IP addresses, like, I mean, if it connected to people higher up in the organization, do you think that makes it like, if let's say it's just an email that was sent to somebody, there's no response. I mean, how severe would that even be? Like, what? I guess like my question is like, let's say the guy sent an email to Masai Ujiri, that in and of itself doesn't seem like it would be enough to be like, oh, well, Masai was directly involved, So but I guess like I don't know. Obviously, I'm not a lawyer, but is that something that it could get messy in that scenario if that's somebody who was involved there?
Yeah, I mean, I don't expect that level of involvement just because of the nature of the information. Do I expect my GM to be jumping into the Synergy account and looking at clips and of the Nuggets and the Pacers and maybe thousands of clips of the Raptors? I expect that to be sort of my lower level video analytics team. Now, all these teams have, all across sports have really, high-powered video analytics teams, and we understand the value that it brings. So I don't know that it necessarily has to go up to, the general manager for it to, cause disruption. Now, what's the goal? It's an interesting question, right? So, I mean, they chose this even more public and different in nature forum of going to court and saying this isn't just like you broke some rules, but it's not. This is not like tampering. This is not the type of thing that we want the commissioner to handle. But we have the 7 or 8 different counts of civil wrongs that you guys did. So is part of that, I don't want to use the word gamesmanship, but leverage and creating some turmoil. This is a rough thing for a new head coach, hasn't coached a game yet, to be hit with as he walks into an organization. So I guess the right word is gamesmanship. So you are inflicting a little bit of potential pain on a rival. Is the end goal? Do you think do you believe in your liability case and your damages case, and you think you can extract a pound of flesh that's more than you would otherwise get with a league, or that the existence of this pushes the league to be stronger on this, or gives you some leverage? Those are kind of all thoughts that occur as to where they might be thinking. But all of it, guesswork, somewhat educated guesswork, but guesswork. Mm-hmm.
Is there anything that you'd like to plug before we get out of here? Sorry.
No problem. Of course. Thank you. Yeah, so the only thing I wanted to plug, is, well, first of all, before plugging, I just wanted to say how much I appreciate the work that you guys do out there. You guys make the experience of watching Knicks games and being a Knicks fan that much better. For me, the only thing I want to mention is that aside from being an intellectual property lawyer who likes talking about this stuff, the other project that I have going on is a side project called Lawyering While Human. I'm on Twitter at law_while_human. That's focused on mental health and mental well-being in the workplace. I focus on the legal workplace because that's what I know, but I think the while human part is more important than the lawyering part, and we all use a bit of that. So I just wanted to give that a mention, and appreciate you having me on.
Yeah, no. Again, appreciate your time. Thank you so much for coming on. Thank you for helping us hopefully better understand what exactly is going on here. Obviously, not as safe. I guess actually one last question. We didn't even get. I'll ask you this: is there any what is the timeline here that we would expect to get court dates and all this type of stuff?
Yeah, I mean, so usually when you file a complaint, the defendant has 20 days to answer. Almost always they'll ask for an extension of 30 or 45 or 60 days and be kind of granted that pro forma to get an opportunity to get their ducks in a row a little bit. So I think, we'll probably see an answer in the next month or two. The other thing they could do in lieu of answers, they could move to dismiss. So they could have a theory they could push that theory that this is the wrong forum and move to dismiss. So that the timing for that would be the same. But then assuming it moves forward, the court will have a status conference at some point and set a schedule. But these cases are, multi-year affairs. There's going to be, discovery and document requests and depositions and that's the fact piece. And then there'll be experts talking about various aspects, including damages, and there'll be the opportunity to make motions and get rid of some of these claims and make arguments about that. So it's kind of, if you see this all the way through, which is one of the reasons that a lot of these cases do ultimately settle or get resolved earlier, it's, multi-year affair is what we're talking. So I think, if the league takes a look at this, I assume even if there's a factual investigation, it'll be on a faster time frame than that.
Okay, and I'm sorry, I know that we said we're gonna end it. One just last thing, I want to read this out, and then just your final thoughts. A federal lawsuit could lead to pretrial discovery where testimony and evidence, emails, texts, etc., generate public disclosures of sensitive financial information and/or potentially embarrassing statements. From a franchise law perspective, a lawsuit pitting teams against each other arguably undermines the concept of an association of member teams. These teams compete, but they are also expected to value esprit de corps and to work together to maximize the league's overarching business interests. That's why leagues are viewed under the law as joint ventures rather than a group of unrelated business competitors. I'm assuming that is kind of what we're talking about, or what you were talking about, rather, when you're saying they would argue like, hey, this is not the forum for this. This is not how we do business. But like, how messy is, a lot of this pretrial discovery, like, testimony? I mean, who would, can the Raptors, pull testimony from people that the Knicks may not want? And could this get uncomfortable for the Knicks then too? I guess is my question.
So a couple things. So first of all, so discovery, and pretrial discovery in the U.S., the discovery rules are very broad. Once you're in litigation, if it's something that's that could lead to discoverable evidence, your courts are going to let you ask for it. And that usually takes the form of asking for documents, and that's the texts and emails and all sorts of. So and that can be hard to collect and expensive and all that stuff. Depositions. So you can get a lot of information. If the Raptors have counterclaims, they can bring counterclaims. I don't know that they would here, and take discovery the other way. But all these cases, as to the thing about embarrassing information, getting out into the public domain, or sensitive financial information, all of these cases are going to have what's called a protective order in place, a confidentiality order. So if you have to disclose sensitive information, you might say, hey, only the lawyers can look at this. You can't disclose this. Just because you produce something in a lawsuit doesn't mean you can then run around and just leak it, put it out in the public domain. In fact, most cases have specific orders that say don't do that. So I don't know that that's a big concern, but the point in what you read about them being kind of this association, kind of like a franchisee model where, like, yes, the Knicks and the Raptors and MSG and Maple Leaf, they're different businesses, but they're all part of the NBA as a collective. I think that's why we have a document like the NBA Constitution that vests that broad power in the commissioner. Now, the whole esprit de corps, and I think what this really pushes is the reason that we didn't go to court in Spygate. No one filed an unfair competition claim, and that we had investigations in all these other cases, the Astros cheating scandal. Is that because of an unwritten rule that says, like, hey, we should resolve this stuff internally through league investigations that everyone kind of abides by, or is that the correct interpretation of the Constitution that says, hey, this is exclusively in the power of the league and nobody else, and you're not allowed to do it elsewhere? This case is going to, if they press it, is going to sort of test which one of those things is true.
Yeah, well, in Spygate, the interesting thing was how the league just literally burned the tape and never sent it out. So maybe the Knicks are like, hey, we don't want that to happen. We want things to come out potentially. So that's that. Mike, again, thank you so much for your time. Happy to do this again if we get some more info down the line. But until then, thank you so much. Thanks to everybody for listening. Thank you for the contributions. That was fun, and we will do it again soon. Enjoy the rest of your night, and look out for the pod that should be dropping either Thursday or Friday, and maybe adding a new pod to the rotation. Be on the lookout for it, guys. All right. Thank you so much to everybody. Have a great night.
Thanks all.